Hello and welcome to our case presentation of Bruce and Dyer. Today we have presenting myself, Alexandra, David, Nick, and Kenjo. Today you're hearing the case between Bruce and Dyer. It was a trial between the two in Ontario in the Ontario High Court of Justice, and it was heard by Judge Ferguson. Bruce is the plaintiff and Dr. Dyer is the defendant. The defendant attempted to pass the plaintiff's car on the highway on a number of occasions, but on each attempt, the plaintiff increased his vehicle's speed to prevent the defendant from re-entering the traffic lane. After the defendant had followed the plaintiff for 16 kilometers, the plaintiff stopped his car on the paved part of the highway, blocking the defendant's passage. The plaintiff then got out of his car and, gesturing with his wrist, walked back to the defendant's car. The defendant got out of his car, and when the parties met, the defendant struck the plaintiff on his chin, causing a serious fracture to his deceased jaw. The plaintiff brought an action against the defendant for damages of assault.
If the plaintiff has nothing to add, I will ask that the defendant come up for his final words. With no more facts to be brought up to the court, I will retire to my study to decide whether the defendant, Dr. Dyer, is liable for damages in the assault suffered by the plaintiff, Mr. Bruce. After careful consideration of all the evidence, I find that the defendant, Dr. Dyer, is not liable for damages suffered by the plaintiff. For my reasonings, there are many, but I will start out with there need be no actual intention or power to use violence, for it is enough if the plaintiff, on reasonable grounds, believe that he is in danger of it. More modern cases point out that even if it appears later that no violence was intended, it is sufficient if the defendant or a reasonable man or woman thinks that it is intended. Bruce had not only emerged from his vehicle shaking his fist, in addition, he blocked the defendant's passage on the road. In my opinion, that blocking action on his part was an assault. If the plaintiff, in the case at bar, had left his auto in some place where subsequently it had blocked the defendant's way, I would have no doubt that the proper remedy would be an action on that case. But when, as here, he drove his car to a position on the road to block the defendant's vehicle, he took active steps to block the defendant and so committed assault upon him. The defendant was then justified in defending himself for the assault thus imposed upon him.
So the second reason is self-defense. The right to strike back in self-defense proceeds from necessity. A person assaulted has a right to hit back in defense of himself and defense of his property or in defense of his way. He has, of course, no right to use excessive force and cannot strike back in defense of his way if there is a way around. Here, however, the evidence is that the traffic from the rear was such that it would have been a highly dangerous maneuver for the defendant to emerge into it, and the Highway Traffic Act, at all events, prohibits proceeding off pavement and onto the shoulder for the purpose of passing. The defendant was effectively blocked for the time being at least. So the third reason was because it was one punch and not beating up. The law requires that the violence of defense be not disproportionate to the severity of the assault. It is, of course, a fact that severe damage was done to the plaintiff. In my opinion, the plea of self-defense is still valid. The defendant struck one blow only. The law does not require him to measure with nicety the degree of force necessary to ward off the attack, even where he inflicts serious injury. This is not a case of beating up. The defendant was highly provoked by the plaintiff's conduct, which was quite unjustified in my view. The plaintiff knew the condition of his own physical state, and one would have thought that he would have, for that reason alone, refrained from such highly provocative conduct. He invited the treatment he received.
This decision has an effect on business in the way they deal with vicarious liability. Companies are liable for the actions of their employees in situations related to work. So, if Dr. Dyer was an employee and on his way to or from work, then the company could potentially be sued and held liable for his actions should he be unable to pay himself.